Are you looking for a loophole to potentially remove that bankruptcy from your credit report? Well, this video is for you. I'm going to be showing you step by step, procedure by procedure, and I'm even going to be showing you the letters that's been utilized to remove tons of bankruptcies, okay? All I need you to do is lock and load. Go ahead and grab you a piece of paper, grab you a drink, and get ready to watch this video. If you need additional assistance, I even have a full-fledged bankruptcy course that you can purchase. Is in the descriptions, okay? Why am I doing this, y'all? I only shake hands with my destiny if you shake hands with yours. Let's get it. Let's go. So let's get started, and maybe that'll fix itself. So again, this is Bankruptcy Masterclass, and so I'm gonna have some Q&A time here, but I am gonna, if I talk too fast, just say, hey, Corey, slow down a little bit. But I am gonna go step by step. Some of this information you already may know, some of this stuff you already may not know. So I'm going to cover it in my slides here. And one of the main things here is, yes, we're covering bankruptcy tonight. Bankruptcy obviously is a legal process for individuals and businesses. And I will tell you, can bankruptcies be removed off of your credit? Yes. But before I go into that, I just want to give you a foundation of bankruptcy. Okay. Obviously, it's a legal process for individuals and bankruptcies and businesses that are unable to meet their financial obligations. We all know what that is. Okay. So one of the key aspects is it doesn't matter if you have a chapter 7 in your case. Most people we're talking about a chapter 7 or chapter 13 in most cases, but in some cases you could have filed a chapter 12 if you're a farmer or something like that, or chapter 11 when it's a business. Okay, but it doesn't matter if it's on your credit. We're going to use the exact same loophole no matter what. Okay, so it doesn't matter. So yes, bankruptcy can be removed from your credit report under certain conditions, and processes must be met. And what I'm going to be showing you tonight is some loopholes that's used, and it's just simple loopholes, nothing Corey's doing, but this is all being done strictly with consumer law. Okay. So ordinarily, when you have a chapter 7, it generally, when they have basically discharged that, you don't owe anything. You go through that process, it's generally on your credit for 10 years. Okay. Chapter 13 is generally on your credit report for 7 years. Okay. Depending on the jurisdictions and different particulars, and specifies where you live at. It could be a little longer, could be a little shorter, but in most cases, it's 7 to 10 years. Okay. So accurate information, verifying accurate information. Obviously, what it says here is bankruptcy information on your credit report. If it's incorrect or if it's outdated, okay, you can dispute to the credit bureaus. Okay, that's not the first thing that you're going to do, but this through a process that you're going to get to before you actually dispute through the credit bureaus. That's what we're going to be talking about tonight. And so it's going to lead you to eventually being able to dispute with the big three. When I say the big three, that's TransUnion, that's Experian, that's Equifax. Okay, but there are going to be some smaller credit bureaus, what we call secondary agencies, that's going to have a play in this as well. And I'm going to cover all that tonight. Okay. Sometimes can you have an early removal of a bankruptcy? Yes, you can. When there is legal errors in your bankruptcy, I will be quite honest with you. There is very rare cases where the bankruptcy filing is actually incorrect or inaccurate. That process is generally done correctly, but in some cases it can be the actual bankruptcy itself filing. If that's incorrect, that can be removed. Or if it's fraud or identity theft, you can have what you call an early removal when it comes to that. Okay. Court orders. Okay. When there's something can be expunged, can something be expunged from your actual record? Yes. Various cases, if it's debt is settled, you want to settle it with the bankruptcy court, you want to settle it with the actual furnishers or the creditors. They may say, you know what, we're going to take this off your record. Does that usually happen? Absolutely not. Okay. The process we're going to be using tonight, though, is with the credit bureaus. Okay. The removal process, because with the Fair Credit Reporting Act that we're going to be touching on here tonight, this is going to allow us to actually use consumer law. And I'm going to give you those laws that we're going to be using here tonight to use this little loophole. This little loophole, I'm going to tell you this right now. Is it sometimes a tedious process? Some people may say that it's tedious. In some cases, it may take 2 months, 3 months, 6 months. It could take a year. By no means am I a lawyer. Let me just tell you that. I'm giving you information. Am I telling you that this is a 100% guarantee? Absolutely not. Have I seen a lot of bankruptcies use this process that we're going to be showing you tonight? Absolutely yes. However, throughout this process, if it took 6 months, if it took 9 months, that's much faster than 10 years being on your credit or 7 years on your credit. Okay. So bankruptcy, an appeal and reconsideration, we just kind of touched on that. If you have a completed bankruptcy or a credit report shows issues related to an appeal to the credit bureaus to review, you could be also a potential removal of a bankruptcy. Okay, so let's get into the consumer laws. Okay, I may ask one of you guys to step off and read something here for me here. If you're not shy, definitely come off mute and read it for me here if you want to, or feel free to chime in when asked. Okay. So one of the laws that we're going to be using, I'm going to run through this portion pretty quickly here, is 15 USC 1681. If I simply click this button here, it'll take us over to Cornell law, which is the accuracy of a report. Okay. That is key. I'm going to read it here. Whenever a consumer reporting agency prepares a consumer report, what does it say? It shall follow reasonable procedures to assure maximum, and that's key. Maximum does not mean 99%. Maximum means 100% possible accuracy of information concerning an individual about whom the report relates. So even though the information is on the bankruptcy is on your actual credit report, when something is inaccurate, that then gives us a loophole to then have it removed. How they actually report it, where they got the information from, that's some of the information that I'm going to be going over here tonight with you. Because we're going to be going through a process of basically setting up the credit bureaus and the secondary agencies to have this off of your report, okay, which I'm going to go step by step on each letter and each process that we're going to go through. But I want to go through a couple of laws. Another one that we're using, these are the laws that's inputted in the letters that we're using, okay? 15 USC 1681 A4, the accuracy and fairness of credit reporting, okay? You want to take screenshots of this, feel free to, but I'm just going over some of the laws that I'm using within this letter. Some people use different approaches to this. I'm just simply giving you the approach that I personally use, okay? And once I go over this, I'm going to tell you one of our first steps that we're going to use here, okay? And if somebody can read this for me, it'd be great. If you want to come off mute and read that. Can you guys see that? Can you see this on the screen?
Yes.
Go ahead and read that for me if somebody don't mind reading it.
I don't mind. 15 USC 1681 A-E. E, the term investigative consumer report, means a consumer report or portion thereof in which information on a consumer's character, general reputation, personal characteristics, or mode of living is obtained through personal interviews with neighbors, friends, or associates of the consumer reported on, or with others with whom he is acquainted or who may have knowledge concerning any such items of information.
That's good right there.
Okay.
So that statement blew me away the first time I knew that. Like, wait a minute. When they do an investigation, are they actually contacting your neighbors? No. Are they doing personal interviews with your friends? No. Your associates? No. But this is very clear in the law. Okay. However, such information shall not include specific factual information on the consumer's credit report obtained directly from the creditor of the consumer, you, or from a consumer reporting agency when such information was obtained directly from a creditor or consumer or from the consumer. Okay. So what that simply is stating, and you can actually, if I click on that, that's going to take you right to Cornell law. You can Google that. That's not me saying that. I'm only actually going to read that here because when I say when we use these loopholes, this is what I'm referencing, if that makes sense. Okay. Going to the last one here in general, in 15 USC 1681 B2 subsection Any consumer reporting agency may furnish a consumer report under the following circumstances and no other. In response to the order of court of having jurisdiction to issue such an order, subpoena issued in connection with proceeding before a federal grand jury, or a subpoena issued in accordance with section blah, blah, blah. You can see there. But the second one says this: in accordance with written instructions of the consumer to whom it relates. Did you give them permission? Did you write them a letter to say that they can put this on your consumer report? Probably not. They probably did not do an investigation. Okay. So I just wanted to just touch on those laws, because those are referenced in the letters that I'm going to be giving. Okay. So the removal of a bankruptcy, like I said before, can it be a difficult process? Yes, it can. But can it be done? Yes. And I don't want to even say difficult. I would recommend that you, one, grab yourself a folder, a notebook, compile all your information together as we go through these steps here tonight, because through this process, it's going to be very, I haven't seen anyone go through the process step by step that haven't been successful in removing a bankruptcy. The ones that do not, they either miss a step or they do not finish the process. Because just because someone comes back as verified doesn't mean that you can't continue the process. Okay, so let's get started. Step one. But before I even go in here, I want to say before I go into this step one, the very first thing that you always want to do, and if you're in our course already, the very first thing I tell you to always do is correct your personal information. Why? Because your personal information is attached with a little ID number on your credit report that is attached to negative information. So what does that mean? On your credit report, you could have your name listed 10 different ways. So if you're John Doe Jr., it should say John Doe Jr., not John Doe, or not John middle initial Doe. Whatever your name is, whatever your birth name is, exactly as it should be, that's how it should be listed. So you should have one name on your actual credit report. And then you want to also update your address, okay? Because that address is also tied to negative information on your actual credit report. So one, I want you to always do that. In our course and everything, we have personal information letters that you can utilize, but you can always call the big three, also Experian, TransUnion, Equifax, and say, hey, I want to update my information. And listen, sometimes you're going to get somebody on the telephone and say, hey, you can't do that. You just hang up, call back again until you get the person that can update your personal information. You want to have one name, one address. Okay. Why? Because that address is tied to negative information. And let me tell you a little bit of a secret. If you have some negative information or something on there and they just will not remove your address, here's a little loophole for you. Go back, for an example, if you have negative information with XYZ company and it's tied to that old address, or if it's good information, you can always update your information with them. And then that way it's no longer tied to that negative address. So if you used to live at 100 Jones Way and it's a negative account, you need to let them know you now live at 1000 Johnson Street. Okay. So that's another way to do it if they will not update your address. Now, that being said, very first thing you want to do after you've done that is get your actual credit reports from annual credit report. Why? Because this is what's going to set you up. Because down the line, if you end up suing the credit bureaus, they're not going to go based on Credit Karma. They're not going to be going based on identity theft. So you want to get your annual credit report. It's completely free. You can get it every 7 days. Okay, that's the very first thing. The second thing is I want you to get your secondary agencies to see who's actually furnishing your actual credit report. Most likely when you look at annual credit report, you're going to see that bankruptcy 9 times out of 10 is going to be reported on all 3. However, the secondary agencies are going to be the ones that actually house your actual credit report. What am I saying by secondary agencies? I mean that such as LexisNexis. If you pull your LexisNexis report, it's going to look like a telephone book. okay? You want to get that, and it's going to also furnish your actual bankruptcy, okay? That is very important that you do that step. The next one, and you can go on LexisNexis, and you can completely go on LexisNexis. I won't click the button here, but you can, well, I'll go ahead and do that. Let's see here. You simply go to LexisNexis. If you simply go there and you just go right to your consumer report, submit an online request, and it's completely done online. Okay, so you have no worries whatsoever in doing that. It's a very easy and very simple process in getting your actual LexisNexis report. The second one that a lot of people miss out on is ARS, Advanced Resolution Services. Unfortunately, you cannot request this one online. You either have to call them at the number listed here at 800-392-8911, or you have to actually write them a letter, which I'm going to give you an example of it here in just a moment. Okay. Another one that you want to reach out to, I'm going to skip over LCI for right now. I'll come back to LCI here in just a second. But Innovis, okay, you want to go to Innovis as well to see if they're holding your bankruptcy. Why am I telling you this? Because these are the secondary agencies. If they're holding your bankruptcy and you get it off of LexisNexis, but ARS is still reporting it, they can be reporting that to the third parties, to the top 3 credit bureaus. Okay, I hope that's making sense. Okay, is that making sense? Just give me a thumbs up in the chat if it's making sense to you. Okay, so you want to go with these 3: LexisNexis report, ARS, Innovis, and I'll come back to LCI, because LCI is another one that holds your bankruptcy. And LCI, they're getting their information. TransUnion is getting their information. They're owned by TransUnion. So what happens is they're getting their bankruptcy information from LCI now. And I'll tell you later on where we want to contact LCI. Okay, so those are your 3 that you want to get. And of course, if you don't want to go to annualcreditreport.com, you can always go directly to Experian, directly to Equifax, directly to TransUnion. Okay, let's keep going. And with this letter, this here is just a letter that you want to go. Remember, I told you, I said ARS, Advanced Resolution Solutions, which Advanced Resolution Services. I'm sorry. What you can do is reach directly out to them by letter. I'm simply writing a formal request of consumer disclosure. This is just simply requesting them to send you your actual credit report. You want to enclose your copy of your driver's license and a copy of your residence, such as your utility bill, such as a telephone statement, recent cable bill, something that you live at that actual address. Okay. And also, you can submit a copy of your social security card if you like as well, but you definitely want to put your driver's license and a recent bill. Make sure your license and that utility bill both match. Okay. And therefore you can get your credit report from them, and then you can say, okay, my credit report is also being housed at ARS. So let's move on. Second step, what you want to do, you want to freeze or opt out of those particular credit agencies, LexisNexis, ARS, and Innovis. You want to freeze those agencies, okay? You want to they're going to give you a little PIN number. So I want you to put this in your package, so when it's time to unfreeze them later on, you can do that, okay? You simply go to LexisNexis, you simply go to ARS, you simply go to Innovis. Okay, if you're already in our course, all of these links go directly to where you need to go. So you have no worries there. So it's all step by step, but just for the sake of this video, I'm not going to go into actual LexisNexis to freeze it, but it is very, you know what, I'll go ahead and do that. You just go to LexisNexis. I'll go ahead because it's pretty quickly here. And it goes straight to security freeze, and you simply fill out the information, the request, and you just basically put in all the information. Is self-explanatory, and you freeze that information. Okay, So that's a very simple process where you do that, where you actually want to freeze the actual information with LexisNexis, with ARS, and that's just putting a stop there and a freeze. So nothing is going on with those actual reports. Some people say freeze them, some people say don't freeze them because the consumer agencies can still get the information, but it does you no harm whatsoever to go ahead and freeze. Okay. So the next step, gather all your information. I'm going to pull you over here. You've now frozen the information. You've gathered all your information. You got your discharge papers together. You got all your court documents together. Now it's time to get what you call a validation letter written to the third parties. Okay, this is not a dispute. I repeat, this is not a dispute. Okay, this is a validation letter that you're going to be writing directly to the third party secondary agencies. Let me say that to the secondary agencies that actually holds your actual bankruptcy. For an example, if LexisNexis is the only one, you want to write this letter to LexisNexis. If it's LexisNexis and ARS, you want to send it to both of them. Okay. So they're going to respond. Keep this in mind. They're going to respond with a letter stating that the account has been validated, and that's okay. Because remember, this is all a setup, okay? Because they're going to tell you that it's been validated or it's been verified, okay? Which is again a violation, which I told you already, of how did they verify that is the key, okay? So that's the number one rule. So what I'm going to show you here, if you can see this letter here, and I'll also pull it up one other place so you can see the full letter. And you definitely don't have to use this particular letter, that's for sure. I'm gonna try to pull it up here and see. So what this letter is, if you can see this letter, give me a thumbs up if you can see it, okay? If not, I'll bring it up on another screen here if you can't see it. But what this letter is, this is your very first letter that's going to go out. Now, these steps, these are in sequence of each other, okay? I'm writing this letter. You don't have to write this exact same letter. You can definitely use this letter. I'm challenging the validity of an alleged bankruptcy listed on my credit report, which is maintained by your agency. Who are you writing this to? The secondary agencies under my social security number. So you want to have your social security number on this letter. I recently disputed this same account with the major credit bureaus. Even though you haven't done that yet, you're telling them that you are. They have indicated that this account has been verified through your records. Please provide me with all the documents and information used to verify this alleged bankruptcy. Again, we're setting them up because we want to actually know how did you actually verify this, okay? I request copies of documents associated with this account that include my signature of the clerk of the court. If you cannot produce such information, I request that you remove this bankruptcy from my file. Again, I'm going to tell you right now, they're going to come back with this as verified. Why? Because they're using a system called Pacer, okay? And Pacer is electronics information. Did they verify this information by going out and doing a real true investigation, family, neighbors, and so forth that we talked about? No. Did you give them written permission to have this on your actual consumer report? No, you did not. But they're using Pacer to verify this. And what you're doing is you're setting them up to let them know later on that they can't use Pacer, but you're simply here. This is a process of not disputing, but you're getting a validation so they can send you a validation letter. So that's what you're utilizing. And right here down below, I'm going to put in this letter here. I'm sorry. I'm going to reach down here. As you can see, I put the laws in this letter. You are required to complete this investigation within 30 days, as stipulated by the Fair Credit Reporting Act, Section 611. I am maintaining detailed records of your actions and request that you do not use automated verification methods such as eOscar. That's another electronic system. So what you're simply telling them is, no, I want to know how you verify this, and don't tell me that you're using eOscar or using some kind of electronic system, okay? Because that's not a true verification based on the Fair Credit Reporting Act. Okay, the next step, and you don't have to wait to get this step done. This can be in concurrent. You can do this simultaneously. You're going to send the bankruptcy court clerk a letter requesting their procedures and policies when reporting this information. What am I saying? What you're going to do is I'm going to show you the letter here. You're going to basically, in layman's terms, you're going to send them the bankruptcy court, or you can actually go to them. Let me back up. Whenever you're sending out any letters, send them certified mail, with the exception of this letter here. It doesn't have to be done certified mail. This particular letter can be mailed directly to the courthouse. If you mail it to the courthouse, I want you to do this. Put inside of that letter, I want you to put a self-addressed envelope back to yourself with a stamp on it, put a little smiley face. You want to make their job as easy as possible. You want to know to them, hey, courthouse, did you send this information to LexisNexis? Did you send this to any credit bureaus? Okay, they're saying that they got this information from the courthouse. What the courthouse is going to tell you is, no, we cannot even send any information to the actual consumer reporting agencies. So again, this is part of the setup. So what you're doing is gathering all of your information. You're sending this letter to the courthouse, or if you really want to be proactive, you can take this directly to the courthouse where your bankruptcy was filed. Take it down there, and they'll give you a letter right on the spot, and they'll say, hey, we don't even report to any consumer reporting agencies. So this is part of your proof. So I'm going to just go further. I wanted to explain that first. Oh, you can't see the rest of that document? You mean the letter? Okay. Let me go ahead and pull up that full letter. Hold on a second here. Let me go ahead and change that view. Give me just a second here. Let me zoom in here. All right, here we go. Here's the letter. Can you see, let me try to put it on. All right, there we go. You want to first, this is your first, this is that first letter that you're sending to the third party. So as you can see here, I got the name here. I got it to whoever that third party or secondary agency is, LexisNexis, ARS, Innovis, whoever's holding that. So you have it here, social security number. Here's the first part of that letter. Here. And down below here, if you want to take a screenshot here, that's basically the meat of the letter. And I'm also letting you know, failure to respond satisfactory within 30 days, seek $1,000 per violation, because this can be a violation, and you can later, I don't teach this, but you can later on actually sue. Okay. So this is the letter here. Hope you got a picture of that. All right, let's bring this back up. So now, what I'm going to do here is instead of showing you that letter here, I'm going to bring it up here, the letter to the courthouse. Let me go ahead and bring it up here so you can see it a little better. This here is a letter directly to the courthouse. You want to name, and again, if you're sending this, make sure you send that envelope with a self-addressed stamp back to you if you're not going down there to the court, okay? So you want to address this directly to the county clerk's name, okay, the courthouse, the address, so forth. And if you have that docket number, go ahead and put that docket number on there, okay? And what this letter is, this is a request for procedures and policies regarding reporting information to the credit bureaus, okay? So if you want to take a snapshot here, and this document is completely within our course as well. It's just all you got to do is fill in where the highlighted area is. And you can, this is just an example or a template. And it simply says, I hope this letter finds you well. I'm writing to request regarding procedures and policies of bankruptcy court and reporting bankruptcy information to the credit bureaus, okay? Excluding PACER, okay? Again, I'm excluding PACER. And they're gonna write you back saying, hey, we don't report anything to the actual consumer reporting agency. So let me go ahead and give you the bottom half of that letter, so you can see it. If you want to take a screenshot. Let me try to zoom out real quick here and see if you can get the whole letter on one sheet. All right, that's gonna be pretty small for you to see it, but if you take a screenshot, you might be able to zoom in then. There you go. I try to give you the whole letter. But there you go. Okay, and that's going to be the letter again. So far, what have you done? You've already sent one, the validation letter. Okay, so you sent your validation letter directly to I can't talk all of a sudden. You sent your validation letter directly to LexisNexis. Let's just use LexisNexis as an example. But again, it could be LexisNexis, it could be ARS, it could be Enemies. Whoever's furnishing the secondary agency that actually holds that, you've sent them a validation letter. You've done that. So now what have you done? You now have sent a letter to the courthouse. You've received that letter back. The courthouse is now saying what? Hey, we don't report anything. So you're gonna put that letter off to the side. You're not gonna do anything with it yet. Okay. So now what are we gonna do? Oops. Sorry. So you sent your courthouse. I went through your letter to the courthouse. So now, step 5. What are we going to do now? Send a letter to LexisNexis and or the third party agency after they have a false allegation. So now what? Remember they sent you back saying what? They sent you back saying it's verified. So now let me show you that letter. What you want to do is gather the original letter that they sent you saying, hey, this has been verified, okay, that you sent to LexisNexis. Okay, return that letter from the bankruptcy court. Okay, so now you got your verified letter, you got that. You got your letter from the courthouse saying, the courthouse didn't give you this information. Okay, so since they claim that they investigated and they verified, but Congress says what? An investigation, they had to do what? An interview of consumer, neighbors, friends, or associates of consumers, not using such verification as PACER. So again, this is where we're setting them up for the loophole. Okay. So what you're going to do is you're going to send them back a letter saying, no, this is not right. And I want to give you an example of that here in just a second. Okay. So here we go. You can even, as I said here, you can even call, in this case, you can call them. Can it be removed in a call? Yes. I personally have not done the calling method, but some people have actually called. You might be on hold and they will take it off because LexisNexis, they like, hey, I don't want no fire. Okay. So let me show you that letter. I'm going to bring it up here so you can see it a little better. We're still fighting with LexisNexis. We have not touched the main credit bureaus yet. Okay. Are you guys following me? Give me a thumbs up. Just give me a thumbs up if you're following. All right. Okay, gotcha. All right, so here we go. Let me zoom in on this letter. Got it. All right, so here we go with this letter. This here is again, this is after they have falsely, they told a lie. That's basically what you're saying. You caught them in a lie. Okay. So what you're basically going to write a letter to them, and this is going to be name, your name, address, your social security number, LexisNexis, or if it's LexisNexis or ARS. Okay. Notice of fair reporting, notice of fair reporting act violation, inaccurate reporting of bankruptcy information. So what are you going to say in this letter? I'm writing to bring to your attention a potential violation of the Fair Credit Reporting Act in relation to reporting of a bankruptcy information. According to my credit report obtained from LexisNexis, it appears that LexisNexis, I'm sorry, obtained from my credit report, it could be whatever that credit bureau that you obtained it from. Okay. It appears that LexisNexis has reported bankruptcy information that is inaccurate and misleading. Okay. The bankruptcy information reported by LexisNexis states that you received the information from the courts. Again, what you're asking them from initially, they came back and said it's been verified. Okay. So they're going to tell you that it's been verified either by electronically, by PACER. They're not going to tell you that. They're going to say, I got the information from the courts. Okay. So this is where I'm now substituting that information in, and I'm now saying, states that you received the information from the courts. However, it is my understanding that the courts do not provide bankruptcy information directly to the credit bureau, which I have enclosed the letter directly from the bankruptcy court. So what am I saying now? In this letter, I'm also going to attach the letter that I received from the court saying we didn't report this information to the consumer reporting agencies. Okay. This raises concerns regarding this accuracy and validity of the information and so forth. And then I'm going to give you here. And then this letter just go ahead and basically says, I want you to take this off of my actual credit report immediately. Okay. In most cases, once you now have submitted this particular letter, LexisNexis, they don't want nothing. They'll go ahead and take this off. Your fight is with the actual credit bureaus. But once you get it off of your LexisNexis report, the actual credit bureaus, now they can't verify with LexisNexis. So therefore, the law says if they cannot verify it, it must come off of your actual credit report. So what you're now wanting in return is that letter from LexisNexis saying, hey, we're deleting this off of your records. And once they deleted it off of your actual records, because they could not verify it, that's where you say, I got you. And that's the letter that we're going to be now compiling now to now go to the actual big three. Okay. So I'm going to scroll down so you can copy this letter in its entirety. And what I've done is put the laws here that I'm utilizing. And again, do you have to have this exact letter? No, you don't. You can definitely write your own letter. That's one page. There you go. Let me try to zoom out so you can take a picture of it. That's pretty small. So that's page one. You want to take a picture. That's page two. Take a picture. And then that's page three. Take a picture. Yes, everything is in the library. Everything that I'm saying is completely, you don't have to take a picture. I'm just saying for people that want to do, if you're already in the course, every single thing that I'm saying is in the library and in the course. Absolutely. You don't have to take any pictures. You just, and what you would do is click the button and you just enter in your information. All of that's highlighted. Absolutely. So let's go back. Okay. So now it's time for the good stuff. Okay. Now that you've done that, again, it's now time. This is not a dispute. I repeat, this is where most people mess up in the process. Again, all of these processes that you're doing, you can do these back to back. You're just waiting on a little information with that last one because you're waiting on LexisNexis to send you back that initial verification before you respond back. Okay. But this letter, this is your very first letter to the big three: Experian, TransUnion, and Equifax. Okay. With this particular letter, I repeat, this is not a dispute in this case. What are you saying to them? You are sending this letter to request information about the methods used to verify the bankruptcy listed on your actual credit report. That's all you're asking them in this case. You're not disputing it. You have the right, based on the law, to ask them what method did you use to verify the bankruptcy and have it on my actual credit report. Okay, you know the answer already, but you're setting them up as well. You already have prepared all your rebuttals already. You already have the information taken off of LexisNexis. You already have the information from the courthouse. You have all of that, but that's not where you're gonna input all of that here. Not yet. Okay, so in this letter, it's pretty simple here. I recently reviewed this letter is going to be to the big three. So you're going to send a letter to Experian, Equifax, TransUnion. Okay, so let me pull up the full letter. Let me zoom in. I hope this is making sense. And I'm going to have some Q&A. All right, so this right here, what you're doing here, this is a very simple letter to the credit bureaus. Again, you want to send your driver's license. You want to put the last four of your social security number. You want to send this certified mail. You want to also send this with your utility bill or proof of residence. I recently reviewed my credit report and I noticed a negative entry related to a bankruptcy, Chapter 7 or Chapter 13, whatever applies to you, reported under my social security number. I am writing to inquire about the methods and procedures you use to retrieve and list the bankruptcy information on my credit file. That's all. Again, this is not a dispute. Please be advised, I am not disputing the accuracy or validity of this account. My request is solely to understand the specific methods and processes you use to verify and include the bankruptcy information in my report. I am interested in knowing how this information was obtained and verified. Please refrain from responding with a standard verified response, as my intent is not to dispute information. My intent is not to dispute the information, but gain clarity on the verification methods. Okay, thank you very much for your attention to this matter. Again, this here is not a dispute in this process. Again, the only thing you're wanting from them is what? How did they verify? Why? Because this is where it gets good, because now you've gathered all of your information. So let me go back here. Now, after you receive that information back from them, now it's time to do an actual dispute. Okay, they're going to send you back something. Okay, you only do this step here. You only file a dispute with the big three: Experian, TransUnion, Equifax, if once the bankruptcy has been removed from LexisNexis or the secondary agencies, So it's got to be removed. You got that letter from LexisNexis, because that's your goal. You've already completed those 1 through 6 steps, received all your responses back. You got your courthouse letter, yes. You got your deletion letter from LexisNexis, yes. You got your letter back from the big three. Saying they're going to tell you how they actually verify what method that they use. You're going to have that. So now you send an official dispute letter to each credit bureau, one to Experian, one to Equifax, one to TransUnion. How you going to send it? Certified mail. Okay. Enclosed with the letter, a copy of the third party LexisNexis, where they deleted the bankruptcy from the report. Let me just read here so I don't miss anything. A copy of the letter from the bankruptcy court clerk's office stating they did not furnish the information to the credit bureaus. This will provide proof of delivery and ensure that the credit bureaus receive the dispute as well. Keep all copies and letters, okay? Keep everything you do, make copies. So let's look at that third letter, that dispute letter. Let me pull it up here. Now, this is your official dispute. Okay. So now what am I saying? On this date you sent the bankruptcy letter, okay? I requested that you disclose the method used to verify. So what date am I putting here? I'm putting the date that I sent the previous letter to the big three here, because I sent them a letter on XYZ date, and I said, hey, I want the method that you used. I request that you disclose the method used to verify the alleged bankruptcy reported on my file. Your response, because you now have gotten a response back from them. Your response enclosed in this with this letter. So you're going to send them back the letter that they sent you, okay, indicating that the bankruptcy was verified by i.e. LexisNexis or i.e. the bankruptcy court, okay, or i.e. ARS. Whoever they put in that letter, that's what you're going to input into this particular letter where it's highlighted. Okay. So the next part of that letter is, I am disgusted by this response. After contacting, you don't have to put that. I'm just saying this is what I got in my letter here. After contacting LexisNexis or the bankruptcy court, or ARS, I was informed that they could not verify this information themselves. As a result, they have removed this bankruptcy from their records. This indicates that the bankruptcy information is considered now unverified, and according to the Fair Credit Reporting Act, they got to remove it from your credit report immediately. Because what happens is, the big three got to get their information from somewhere. Where are they getting their information? According to the law, the Fair Credit Reporting Act, which I put down here, they have to have it verified. If LexisNexis can't verify it, where did you get the information? If it's unverified with LexisNexis or ARS or the courts, it has to now come off your credit report. So this is where that official dispute comes into effect. I'm not telling you that they're going to try to put up a fight, because remember, they get paid to have this information on your actual credit report. That's how they do. And they will lie. They will send you stall letters. They will send you all types of things to keep it on your actual credit report. Okay. So just going a little farther here, the credit reporting agency must remove or correct inaccurate. And as you can see, where I highlighted here in this area here, I quote, as stated in the Fair Credit Reporting Act, a credit reporting agency must remove or correct inaccurate or unverified information from its files, usually within 30 days after you dispute it. However, the credit reporting agency is not required to remove accurate data from your file unless it is outdated or it cannot be verified. That is directly from the Fair Credit Reporting Act. That's why it's in quotes. Enclosed, please find this letter from LexisNexis or Bankruptcy Court or ARS confirming the removal of this bankruptcy from your records. Given this information is not verified, it should be deleted from my credit report. Additionally, I wish to address potential violations. This is where I've submitted the laws that we went over earlier. Down below here, I've indicated this can be potential $1,000 per violation. Okay, so I put that all in my letter. Now, saying this, does it always come off of your credit report? Because I've told them now, hey, I want this off of my credit report. Will it always come off? No. Sometimes it'll come off of one credit report and not the other credit report. So you want to send what you call a follow-up letter. Okay. With a follow-up, if it comes back, if they just send you a letter saying, oh, it's verified again. If it does not come off of your credit report, now what you're going to do is send a follow-up to them. This is a follow-up letter. So now this is, say, for example, it came off of Experian, it didn't come off of Equifax and TransUnion. Again, keep very detailed records. You want to say on this date that you sent letter 2, the second letter, I sent this on X date. I provided evidence showing that the bankruptcy entry on my credit report was unverified. So this letter is here basically saying, I contacted you. I sent in the information from LexisNexis. I sent in the information from the courts. They confirmed that they could not verify it, but yet you're still not removing it from my records. I've told you that what the Fair Credit Reporting Act has stated in this case. And I'm going to go ahead and make this letter so it's legible so everybody can see it here. So if you need to take a picture, I apologize, I didn't do that on the last letter. Oops. You zoom out. You want to take a picture? There you go. And again, this is your follow-up letter. And as you notice, I'm going to CC on this particular case, I'm going to CC the Consumer Financial Protection Bureau and the Better Business Bureau and the Attorney General's office. This is not just a threat. If they do not remove this, we are going to do exactly that. Okay, we're going to file a complaint with the Consumer Financial Protection Bureau. We're going to get with the Attorney General office of that particular state. Okay, so now, what have you done? You have went through the steps. You have had it removed from the secondary agencies. Yes. You have now filed an official dispute. You have now sent a follow-up letter and they still coming back and saying it's verified. So you told them basically, yes, I'm going to file a complaint. So the next thing is what you want to do. If it still has not come off of your actual credit report, you want to file a complaint with the CFPB. You want to also get with the Attorney General's office of that state and also file that as well. I'm going to show you, but generally speaking, it'll come off once you file a CFPB Consumer Financial Protection Bureau complaint. Let me show you how to do that, okay? This particular complaint, though, is particular, though, to this actual filing. And that's why I want to show you in screenshots how you actually file this, okay? And again, this will all be within the course as well. So here we go, how to file this. So if you've never signed up, you must first go into the Consumer Financial Protection Bureau, okay? Go to Consumer Financial Protection Bureau, CFPB. You want to log in or create a case. And then the first thing you're going to see on the top right-hand corner is you're going to start a complaint. So the very first screen you're going to see after you start that complaint, choose the product or service that best match your complaint. You want to go credit. First one is credit reporting or other personal consumer reports. That's the one you want to choose here. Credit reporting or other personal consumer reports. The next screen you're going to see, what type of credit reporting product? Credit reporting. Don't use the other one. This is credit reporting, because this is all in how they're actually reporting on your actual credit report. So you can take a screenshot here. The next screen you're going to see, what type of problem are you having? This is where most people mess up with the CFPB, and this will lead to your complaint not being able to be taken off of your actual credit report, okay? Most people put incorrect information on my report. You want to put problem with company's investigation, because this is what? This is a problem with how they actually investigated your actual, how they're actually investigated your actual bankruptcy. That's what this is all about. So you don't want to put incorrect information on your credit report. We're not using that in this case. In many CFPB complaints, that is what you're using. But in this case, make sure you put problem with company's investigation into existing problem. Okay. The next one, which best describes your problem? You want to go to their investigation did not fix an error on my credit report. Have you already tried to fix this problem? Yes, we tried multiple times in this case. Yes. Did you request information from the company? No, it was nothing I requested from them. We asked them to fix the problem, but we didn't actually ask them to have anything. The next one, if you want to take a screenshot here, only thing, this is what you want to do here. You want to put in here, what is the actual summary of what happened? I just put an example here, but what you want to put in here is what actually happened. This, you want to put all of your details. What did you do first? I'm writing a formal complaint under an unresolved issue with my credit reports. On January the 1st, I submitted a letter. Now, right here, you do not want to put TransUnion, Equifax, and Experian. You want to put one of the three, because you're going to be filing 3 different complaints, one with Experian, one with Equifax, one with TransUnion. Or if they're whoever's holding it still with the major 3, you're going to file 3 different complaints. So right here, you want to only put, I submitted a letter to TransUnion. I submitted a letter to Equifax. I submitted a letter to Experian, disputing the validity of a bankruptcy entry listed on my credit report. In their response, they claim to have verified this bankruptcy through LexisNexis. But we already know, subsequently, I contacted LexisNexis to dispute this entry. They could not verify the bankruptcy, leading them to remove it from their database, i.e. LexisNexis. Despite providing this evidence to TransUnion, Equifax, or Experian on X date, you put in the date that you provided that information, requesting the removal of the unverified item in accordance with the Fair Credit Reporting Act. They have refused to delete this from my credit report. This unresolved issue is severely impacting you want to make sure you put in there, this is impacting whatever it's impacting, my ability to purchase a home, costing me $1,000 of interest. And according to the Fair Credit Report, this item cannot be verified. Within 30 days, it must be removed from my credit report, which we already know it cannot be verified. So again, am I telling you to put that detail? No. You can put something of that nature. You can put it in ChatGPT, rewrite the letter. Whatever your summary is, you want to put it there. Okay. And last, do not forget this screen. What would be a fair resolution to this issue? Delete this from my credit report. You want this off of your credit report. That is the resolution, period. Okay. Next, don't forget this information. A lot of times it'll say this is optional, but what you want to do is put all of your paperwork and submit the files here. Why? Because this is where you have proof. So you want to go and put all of your proof here, going all the way back to that first letter that you sent, the validity to have it removed from LexisNexis. You want to have that letter. You want to have LexisNexis deletion from where they could not verify and they deleted it from your credit report. You want to have the information from the courthouse saying that they did not send this information. you want to send the first letter saying that they verified it from the big three, that they said they verified. You want to send the follow-up letter that you sent them, and they then repeatedly said it was verified the second time as well. You want to also put your driver's license. You want to put your copy of your most current utility bill here. You want to upload all of your information here because those are your supporting documents. You want to act as if you're in court, okay? And you have to submit proof here. And now you've gotten all of your proof. And because of the sake of time, I won't show, I'll do another video here on how to submit to the Attorney General's office, and I'll put that, do another video on here. But you want to submit that all of your information here in this CFPB complaint. And the next screen you're going to see, you want to submit this. Oops. It's going to just have here where you put in the company name. You want to put TransUnion, Equifax, or Experian. Right below, it's going to ask you to put it. I always recommend that you put your social security, last four, date of birth, and how it appears, your name as it appears on your actual credit report. And by now, you should have one name on your credit report, okay? Next screen, do you want to complain about another company? If that bankruptcy is on other companies, you want to answer that as yes, okay? And then this is where you want to put that same information for Equifax, and then it's going to ask you, do you want to have another company? You want to use the other three. So you can submit all three here, but they have to do additional company, Equifax, additional company, TransUnion, Experian, and so forth. Okay. So I'm going to stop sharing my screen here and open it up for any Q&A here that we might have. So I know I went through that kind of fast, but I want to make sure we got questions here. Come off from mute. And just to recap, to give you some steps, what did we do first? We obtained, we obtained our credit reports. Yes. Very first thing is what we did was we sent that validation letter over to LexisNexis, ARS, whoever's holding that actual report. So we already know what they were going to send back. Then we sent the letter to the courthouse after we received the courthouse letter, or we went down there. The next thing is what we did is we sent a letter directly responding to the investigation of the false allegation, saying they got the information from the courthouse. We sent that letter back to LexisNexis for them to delete that. In some cases, do they delete it on the first time with LexisNexis or the secondary agency? The answer to that is no. Sometimes you have to follow back up with them with a follow-up as well. But once you have that deleted, not until then can you dispute. But then remember, that very first letter to the top three credit bureaus, remember, you're not going to send a dispute first. You're going to just send them that first letter to the credit bureaus, the big three, saying, hey, what method did y'all use? Even though you know what they're going to bring back, you just want them to answer that and say, I use XYZ method. So now you already prepared your rebuttal. And once you have all of your things in hand, that's when you want to do your official dispute. So let's go ahead and answer for any Q&A here. And also, I'm gonna share my screen real quick, one more last time. Hold on. And obviously, just to let you know, everything is within our portal. So if you were in our portal, obviously, you can go credit restoration here, and you just go right to bankruptcy. Just like if it was anything else, if it was talking about charge-offs, but in this case, we've been talking about bankruptcies, and it's step-by-step video here. And as I was bringing up each one of those letters, you just go here and it takes you directly to where you need to go. You don't have to worry about this. This is all step-by-step within the course. So you don't have to worry about being off step or anything like that. It literally takes you step-by-step in each process. With each link is going to take you where you need to go. Okay. And just to let you know as well, and stop sharing here. There is two processes. If you, I have a bankruptcy course. If you just said, hey, Corey, all I want is the bankruptcy court by itself. That's all I'm worried about. That's it. I definitely have a bankruptcy course, and I'll definitely put that in the chat. But I also, for anybody in the future want to get it, but I also have our mentorship that allows you to get everything from, yes, our bankruptcy charge-offs, but not just that. Our whole thing is not just, I guess it's better to show you here. As you can see, if you can still see my screen, our whole initiative is not just in credit restoration, but it's in funding, how to help start a business. We take you there, how to go A to Z on how to start a business, A to Z on funding, passive income, how to start a trucking company, how to do digital marketing, Airbnb, mobile homes is coming, funding, business. So you name it, this is our whole mentorship is a full process that you can go, but I want to make sure I answer any questions first.